correct, Ms. Lewis? Okay.
Yes, Judge, we no longer be doing probation revocation hearings unless necessary.
You are correct. Thank you. All right, Ms. Atay, who do you have next to you, please?
Jeremy Campbell, position 10.
Okay. Position 10, and that's going to be a not guilty plea.
Yes, Your Honor, it's a not guilty plea and a bond argument.
Okay. Mr. Jeremy Campbell is accused of battery family violence from April 16th, 2024 under accusation 24 CR 5560D. Mr. Campbell, you've been advised of your rights, and your attorney will be filing a waiver of arraignment and entering a not guilty plea on your behalf. Presently, just give me a moment to switch to the screen. All right, Ms. Atay, you may proceed with your bond argument. He received a $3,000 surety bond on August 9th. Please proceed.
Yes, Your Honor, and you did set that bond. The state is asking in the plea offer for no further violent contact with the complaining witness. So I believe that I've spoken with her, and I believe that the state has spoken with her. She does not want to press charges. She is not afraid of him. He has lived in Georgia all his life. He does take care of 4 minor children. He is in school studying accounting at Atlanta Area Tech. He has been in custody for 22 days, Your Honor. He cannot afford the $3,000 surety bond. He also has no bond on a fleeing charge. He has a hearing for that on September 3rd, and I do hope that a bond will be set there. I am asking for a signature bond through pretrial services based on the fact that the complaining witness states that she does not want to press charges. She's not afraid of him. There's no risk to the community or to this victim or complaining witness. And Your Honor, he's at risk of losing his job. He's already going to be here until September 3rd at least. And he needs to get out and take care of his 4 children who are 10, 6, 2, and also a 10-month-old child. He denies the allegations as stated in the warrant and states that the complaining witness was intoxicated at the time. She had come from a party where she was fighting with other people. And I'm just asking for the $3,000 surety bond to be reduced to $3,000 for bond through pretrial services, even if it's at level 3.
All right. Let's see if he qualifies. Ms. Falk, what's your argument?
Yes, Your Honor. So a couple of things. One, Miss Angelica Moss is here at the Zoom today, and so we would like to sound for her if she would like to speak. Number 2, when we spoke to Miss Moss, our victim advocate, she agreed with our plea offer. And so contrary to what the defense has said, she was actually in agreement with the plea offer. Number 3, the reason Your Honor set in, and this is speculation on my part, may have set a $3,000 surety bond is because of his history. This defendant has 26 cycles, including this case, previous convictions for, previous probation violation, previous 2019 conviction for willful obstruction of an officer felony, where he received 4 years, a 4-year sentence, where he had multiple probation violations subsequent to that, a willful obstruction of an officer and possession of a firearm by a convicted felon in 2019, where he pled guilty in Fulton County, probation violations previous to that, as well as possession of cocaine with intent to distribute, possession of firearm during commission of a felony, where he received a suspended sentence of 5 years, probation of 4 years, where he entered a guilty plea on that case. That's an 18 SC case. Prior to that, he had a 15 SC case where he was found guilty of criminal trespass, possession of marijuana, and abandonment of drugs, as well as willful obstruction. He entered a guilty plea on that case and was sentenced. So that's just in the less than the last 10 years. That is the defendant's history. So not only is he a risk of reoffense, just based on his history, but he also is currently in jail for failing to appear on a fleeing and attempting to elude and a willful obstruction under 21 SC 178592, for which he has a $1,000 surety bond and a no bond. So I think based on the Ayala factors, the fact that he is a risk of reoffense, the fact that he is a flight risk, I think the $3,000 surety bond is more than warranted in this case.
Thank you. Ms. Moss, I think you said she was
Yes,
present.
Angelica Moss, Your Honor.
Ms. Moss, if you would like to contribute to this proceeding, you need to start your video and unmute. All right. Ms. Moss, please raise your right hand. Other right hand. Is that your right hand? Or maybe the video is inverted. I'm not sure. All right. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Well, you've heard the charges that have been brought against Mr. Campbell. You've heard his criminal record history. What would you like to tell us?
Well, I know we never had this problem, and since that happened, we never had anything like this happen. And like they stated, I'm not afraid of him. And we were just trying to get our landscaping business off the ground. I work overnight, and he cares for our 9-month-old child while I'm at work. And I was hoping that he would get a signature bond. I was trying to say this last time, but I couldn't unmute or pull up my video for some reason.
Anything else?
No.
All right. Ms. Attai, anything else to add?
Well, yes, Your Honor, I just would like to clarify that I didn't say that the complaining witness was not okay with the plea offer. I was pointing out that the plea offer includes a no further violent contact with the complaining witness, so that I'm saying that is what she would want. It indicates not afraid of him. And I heard the history, but I didn't hear anything violent, Your Honor. So I am asking for the signature bond through pretrial services. His family is relying on him they have 4 minor children. He has a lot of responsibilities and they have a business that they're trying to run.
And Your Honor, the 2019 felony obstruction is violence. That's the basis of a felony willful obstruction, is doing violence or offering violence to an officer.
No, sometimes you're charged with obstruction. It says no violence offered. So
Not a felony obstruction.
Well, that's neither here nor there. I look at the bond and I'm trying to understand what has changed from the time I addressed this case to the present time. Mr. Campbell has had several bookings with the Fulton County Jail alone since, at least I'm looking since 2017, 2018, 2020. 2022, 2023, 2024, and then again in 2024. Either he misses us a lot or he has an unfortunate run-in with the law on a very systemic basis. I understand if Ms. Moss wants him home, if he's the caregiver or the income earner of the household. However, that in itself does not justify an individual getting a signature bond. Mr. Campbell has a systematic and annual pattern of offending and reoffending. Whether it's Ms. Moss or not, it doesn't matter. And considering the nature of the charges, they may not be violent in some people's eyes, but it may be otherwise violent in others. And Mr. Campbell, you do not qualify for a signature bond. Your criminal record history has come back to haunt you. And this is the result, that you do not qualify for a signature bond. You pose a high risk to reoffend, not necessarily with Ms. Moss, and you pose a high risk of not appearing in court by virtue of the fact you've got a bond surrender at the present time. So please understand the reality of the situation. You do not qualify for a signature bond, at least not from me. Thank you. Case is further notice for trial.
Come on. Next, Your Honor, we're going to go to position number 11. Mr. Reginald Elliott.
Thank you. ACDC, I'll be with you shortly as soon as the deputy says. Mr. Reginald Elliott is case 23 CR 6589F, accused of battery family violence from October 19, 2023. Mr. Elliott, you've been advised of your rights, and your attorney is going to be Ms. Atay. And with regards to Mr. Elliott, this is going to be a waiver of arraignment.
Yes, Your Honor.
Okay. And Mr. Elliott, your attorney is going to file a waiver of arraignment and enter a not guilty plea. Anything else, Ms. Atay?
Nothing?
All right, that case is further notice for trial. Thank you.
Come on. You go. Your Honor, you can go to ACDC.
Thank you. Good morning. I'm addressing those at the Fulton ACDC. My name is Judge Long, and we are going to be addressing each of cases on a one-on-one basis. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Who do we have first?
Good morning, Judge Law. This is going to be number positions 3 through 5, Ms. Atkins. And before I start with her, I do have a quick announcement for number 41. We do need a Spanish interpreter. Mr. Valdez.
All right, Miss Lewis, I'm not sure if we.
Yes, we did request one. One will be on the line shortly.
All
Okay,
right.
thank you.
Mhm.
This is State versus Brittany Atkins. Brittany Atkins has got 3 matters on our calendar this morning. We're going to begin with position 3, 24 CR 5756J. Ms. Atkins, are you aware of the charge brought against you?
Yes, ma'am.
All right. You have got a bench warrant from March 1st, 2024 under case 24 FTA 1130. And then you have a third case, 21 CR 5868J, in which you're accused of battery from September 8th, 2021. With regards to all these 3 cases, you have been advised of your rights, and your attorney is Ms. Atay. Ms. Atay, this is going to be a negotiated plea?
Your Honor, Ms. Falk, did you receive my email? And I didn't see it.
Let me check. Hold on just a moment. When did you send it?
Yesterday around, I think 6.
Okay, hold on.
Looks like it's the only anger management is the condition, Ms. Atay. Was there something else that we're doing?
Yes, Your Honor,
The state will agree to that.
thank you, Your Honor. Thank you, Ms. Falk. Okay, Your Honor, so, if Ms.
We're ready
Falk
to proceed?
state the offer.
Okay.
Yes.
Let's go. But let's go ahead and place Ms. Atkins under oath. Ms. Atkins?
Yes, Your Honor.
We're going to address a negotiated plea. Please raise your right hand. You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes.
All right, Ms. Falk, the recommendation?
Yes, Your Honor. Position 3, the state will agree to null pros upon a plea to position 5. Position 4, the state will agree to null pros as that's the failure to appear that underpins position 5. And position 5, the state has agreed to reduce the charge to a fray. 12 months probation, served 20 days, credit for time served 10 days. That's going to be from October 29th to October 30th, 2021 and August 15th, 2024 until today. Balance probated, 2 days anger management, no contact with Destiny Gunnison, and terminate upon completion of anger management. We did attempt to reach out to Ms. Gunnison. I will let the court know Ms. Gunnison was also charged in this case, which is why the state has agreed to reduce it to a fray. We do ask the defense stipulate to venue factual basis and identification for the purposes of this plea, and we would like to sound from Ms. Destiny Gunnison.
Ms. Gunnison? All right, Ms. Hatay?
And
Do you
we
stipulate?
stipulate, yes, for position 5, we stipulate, Your Honor, and I would like to ask for at least 3 months of probation fees to be waived. She is indigent and has 4 minor children.
I will waive probation fees from now till the end of November. She'll need to start paying probation fees from December 1st, 2024 onwards. All right. Ms. Atkins, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your cases?
All I heard was probation and anger management.
Well, you've got 3 cases, including 1 bench warrant for failure to appear. The state has agreed to dismiss 2 of them, and the only case you'll be dealing with is a conviction for affray if you decide to move forward.
Yes, ma'am. That's fine.
That's your understanding?
Yes, ma'am.
All right. And are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty to affray, you would have to give up your constitutional right to go back to court and have a trial in front of a judge or a jury. You will not get the opportunity to have the assistance of counsel so that you can challenge the evidence brought against you, confront your accuser, present your own defenses and arguments, and have the state carry the burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of affray from September 8th, 2021?
Guilty, Your Honor.
Your sentence is going to be 12 months to serve 20 days, credit for time served 10 days. Your jail time is concluded. You will report to probation on Monday, and that's going to be August. I want to make sure I get the right date, sorry. That's going to be August 26th before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you are reporting to probation once a month, you are to enroll and complete 2 days of anger management classes and have no contact with Destiny Gunnison. Once you complete the 2 anger management classes, your probation will terminate. Your probation fees are waived up to the end of November 30th, 2024. So it would be a great benefit to you if you enroll and complete your anger management classes before November 30th. Otherwise, you will have to continue reporting and start paying probation fees.
Yes, ma'am.
All right. I just got a message from probation. All right. This is a message from probation to the defense counsel. They would like y'all to send in the probation information or victims directly to Ms. Thomas. Okay.
And also, excuse me, Judge, this is Ms. Falk. Can you please make sure that amended accusation is filed before I can put the disposition?
I am doing that now, Ms. Lewis. Thank you.
Okay, I appreciate that. Thank you.
I appreciate it.
All right, Ms. Atkins, that concluded. Thank you.
Thank you.
Next case, please.
Your Honor, we're going to go to Mr. Monte Wilson, and he's position 51 and 52. That's Ms. McLeod's client.
All right, thank you. Good morning, Ms. McLeod.
Good morning, Your Honor.
All right, and let us see. I recently appointed a case from the C calendar to you. Did you get the notice for that?
I don't believe so, Your Honor. What is the name of the person?
Let me have to refresh my memory by looking at the calendars. I just
51 and 52, Monte Wilson.
Okay, but right now let's deal with Mr. Monte Wilson.
Yes.
Mr. Monte Wilson is positions 51 and 52 on the calendar, and his cases are 24 CR 5553E and 5558E. The position 51 are traffic matters stemming from a August 7, 2024 incident, including possession of marijuana less than 1 ounce, possession of a drug-related object, willful obstruction, giving false information, driving without a valid license, no valid insurance, and failure to obey a stop sign. On the position 52 is a theft by shoplifting charge from June 14, 2024. Mr. Wilson, you've been advised of your rights, and your attorney is Ms. McLeod. Ms. McLeod, how are we proceeding with these cases?
Your Honor, this is going to be a negotiated plea this morning.
All right, Mr. Wilson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
You need to speak up, sir.
Yes, ma'am.
Excellent, thank you. All right, Ms. Mokeke, good morning, and what do you have for Mr. Wilson today?
Good morning, Your Honor. For position 51, the state's recommendation is time served to all charges, and that will be 32 days credit for time served, 16 days.
Okay, and position 52, is it the same thing, time served?
Yes, Your Honor, it is the same thing.
All right, and Ms. Maureen McLeod, do you stipulate to the factual basis, venue, and ID for both cases?
I do, Your Honor.
All right. Mr. Wilson, have you consumed any medicine or alcohol recently?
No.
All right, you need to speak up a little louder because we're recording this on Zoom, okay?
No, ma'am.
All right, and have you understood what's going on in your misdemeanor cases with us today?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And has it been explained to you that if you decide to plead guilty to these charges, you would be giving up your right to a trial in front of a judge or a jury to challenge these misdemeanor offenses? You will not go back to court to confront your accuser, challenge the evidence brought against you, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the traffic-related matters in position 51?
Guilty.
How do you plead to the theft by shoplifting on position 52?
Guilty.
Your sentence for all these charges is time served to serve 32 days, credit for time served 16 days. Your obligations for these two cases are over. You will be just addressing whatever is going on in Superior Court with you, okay?
Yes, ma'am.
Good luck, thank you.
Thank you, Your Honor.
Next, Your Honor, can we go to Marietta Annex? That's gonna be position number 29, Mr. Willie Mobley.
All right.
Just gonna be a negotiated plea, semi-negotiated plea, Judge.
Okay. Mr. Willie Mobley is is charged with simple battery family violence. He's located at the Marietta Annex, case number 24 CR 5513A. Does he have any other matters? No? Okay. Mr. Mobley, you have a right to remain silent during the course of these proceedings about the facts of your case. Anything that you choose to say can and will be used against you. You have a right to an attorney, and Mr. Tom White will be representing you. Do you see your attorney on the screen?
Yes.
All right, good. And I'm sorry, Mr. White, with regards to position 29, this is going to be, as you said, a semi-negotiated plea. So Ms. Mokeke, it's my first time with a semi-negotiated. Why did you let me know what you are offering?
The state's offer was 12 months to serve 34 days, credit for time served 17 days, no further contact with the victim, Naya Harper, an FVIP, a stay away from the incident location 557 Westlake Avenue, Northwest Atlanta, and for him to have no firearms.
Right. And Mr. White, what are the changes that you are seeking?
Judge, we're asking for a no further violent contact and to strike the stay away. My understanding is the state has spoken with the complaining witness, Ms. Harper, and they are together, they live together. She wants contact. I was not able to see Mr. Mobley yesterday due to a variety of reasons, so I am not able to confirm that, but that's my.
Miss Naya Harper is on Zoom. Shall she chime in?
Yes, and I will say we did speak to her on the 7th, and she did state that they were breaking up at the time and the defendant wasn't accepting the breakup, and that there hasn't been any violence since this incident, which occurred September 17th, 2023. But on June 25th, 2023, the defendant was accused of robbery against Ms. Harper. And in that case, he was accused of dragging her out of the store, forcing her to the ground, ripping a purse from her hand, from around her neck, and taking her phone. So I think that is why you had ordered the no further contact in his original bond, is because there was just a history of some repeated violence with the same victim and the defendant.
Ms. Naya Harper, if you'd like to contribute to these proceedings, you would need to unmute and start your video. Ms. Naya Harper.
Hello, I'm sorry, I'm at work, so it wasn't work. I don't know if you all can hear me.
I can hear you. If you'd like to raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. What would you like to tell us?
Well, I had spoke with someone on yesterday, and they said we couldn't have contact with each other, but since then we haven't had any violent contact with each other. So I told them it's fine if we have contact. Then we have a daughter together, so we have been in contact since then, since it's been going on.
All right. Are you talking about since the June 2024 case or since last year?
Like since period, we have been having contact like since last year.
So she's been in jail on the other charges.
I'm sorry, I can't hear.
I'm speaking to the judge.
Oh.
He's been in since the 26th.
Well, I understand that, but I'm concerned about the 24 PI case.
Yes, before he was incarcerated, we have been having contact with each other, and he have been around my daughter.
We're talking about something else.
That was 24 PI. Was that 00056? No. Ms. Lewis, or Ms. Mokeke, I don't seem to. It's 24 PI 005677, wasn't it?
Is that the robbery?
That's what I'm asking.
Okay, give me 1 second. Let me look for that.
My point is that he's been in since that day.
My concern is contact with the victim if she is the victim of a robbery matter from just a recent felony case.
So the robbery incident took place in 2023. He may just have been arrested on that robbery charge recently. In that robbery case, he got a $10,000 bond and no further violent contact.
Was it after this incident of September 17th?
It was before the incident of September 17th. The robbery occurred June 25th, 2023.
All right. Okay. All right, Mr. White, I'm going to allow for no further violent contact if these two apparently are working out their situation and they can live together. However, if there is even a whiff of him violating probation or not complying with the domestic violence program, I'm going to authorize probation to revoke and have him be back in jail.
Fair enough, Judge. Thank you.
Mr. And do you stipulate to the factual basis, venue, and ID, Mr. White?
We do, Judge.
Mr. Mobley, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on with this case as well as your open case?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty to the simple battery family violence on September 17th, 2023, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not
Yes,
get
ma'am.
the opportunity to go back to court, confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, as well as have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery domestic violence?
Guilty.
Your sentence is going to be 12 months to serve 34 days, credit for time served 17 days, balance probated. He still has the bond. Has he made bond in the felony case?
He hasn't, Judge. He's going to court next week on those, so he anticipates that to be resolved.
Mr. Mobley,
Yes.
once you are released, you are required to report to probation immediately on the first business day on Monday, Tuesday, or Thursday. Do you understand, sir?
Yes, ma'am.
This will be for your misdemeanor probation, nothing to do with felony probation. Do you understand?
Yes, ma'am.
On your misdemeanor probation, you have to report on the first business day at 132 Mitchell Street. While you're on probation, you will enroll in a 24-week domestic violence intervention program. You must enroll in that program within 30 days of being released. I'm not going to give you any more extensions. Within 30 days, do you understand, sir?
Yes, ma'am.
That means by your second probation visit, you must show proof of enrollment. You must attend those weekly classes every week with no skips and absences. If you don't comply and you don't finish those classes, probation is authorized to revoke your probation and have you serve out the rest of the year in jail.
All right.
You are to have no further violent contact with Ms. Naya Harper. You are not to engage in any physical or verbal altercations with Ms. Harper. If there is any altercation and the police get involved, you will be back in jail with your probation revoked. You may return to the 557 Westlake Avenue location if that's where you live with Ms. Harper. But please keep in mind, you are not allowed to own or possess any firearms. You cannot have any firearms on your person, in your home, anywhere near you. And that's it. Report to probation every month for the remainder of the 12 months. Thank you.
Thank you.
Thank you, Your Honor.
Mhm.
This is gonna be number 6, Ms. Bodie.
Hello. Yes. Who are you, please?
Daisy Bodie.
No, not you. The lady who's on A. Smith. Miss Lewis, could you please mute that screen?
Me? That's me.
Thank you. All right. We are addressing Daisy Bodie at Fulton ACDC, who's charged with battery causing substantial physical harm under case number 19 CR 8547J. Ms. Bodie also has a bench warrant under 24 FTA 1134. I believe those are the two cases addressing her. Ms. Bodie, you've been advised of your rights, and your attorney is going to be Ms. Atay, 6 and 7. And Ms. Atay, this is going to be a negotiated plea?
Your Honor, I did email Ms. Falk about Ms. Bodie's case.
Ms. Falk?
I appear to be very popular, Your Honor. Let me take a look at that.
You're always popular. Never think
It's the same email, Ms. Falk.
Okay, let me just take a look. Well, Ms. Attai, the charge is already battery. So I'm not sure, even though it says battery substantial physical harm, that's just battery. It's just it's just laying out, because there's also visible harm. It's just a code section quirk, but it's citing from the same code section as battery.
Okay, and Ms. Falk.
And no, I'm not willing to reduce the anger awareness. But it's up to her if she wants to continue. Like I said, I am agreeable to termination upon her completion of that anger management.
Okay, and you wouldn't be okay with a 2-day anger awareness? I mean, it's from 2019 and that was her last arrest 5 years ago.
And how about this? I'll split the baby and reduce it to 4 weeks anger management.
Okay, that sounds good.
Okay.
Thank you.
All right.
Okay, so it's a negotiated plea, Your Honor.
Ms. Bodie, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Ms. Falk?
Yes, Your Honor. The recommendation on this case is 12 months served 96 days, credit for time served 48 days. That's going to be from October 19th to November 27th of 2019, August 15th, 2024 until today. Balance will be probated, no further violent contact with DeMaffiette Scott. 4 weeks anger management, and she may terminate upon completion of the anger management courses. We would like to sound for DeMaffiette Scott, and as we would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
All right. Do you so stipulate, Ms. Latte?
Yes.
All right. Ms. Lewis, could you place A. Smith in the waiting room, please? Thank you. All right. Ms. Bodie, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case?
I think so.
You think so?
Yes, I do. I mean,
All right. And are you satisfied with your legal services?
yes.
And has it been explained to you that if you decide to plead guilty to battery causing substantial physical harm, that you would have to give up your constitutional right to a trial in front of a judge or a jury?
Yes,
You will
ma'am.
not go back to court. You will not confront your accuser. You will not get a chance to challenge the evidence brought against you, present defenses and arguments, as well as have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of battery?
Guilty.
Your sentence is going to be 12 months to serve 96 days, credit for time served 48 days. The remainder of the time will be on probation. You'll report to probation on Monday, August 26th before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. Does she have any other holds, Ms. Ate?
No, she doesn't, Your Honor. And I'm sorry, can we waive 3 months? Can you waive 3 months of probation fees? She is indigent and has struggled with homelessness.
I will waive it up to and including the end of November 30th, 2024. So which means that if she hasn't completed anger management classes by then, she'll have to start paying probation fees from December 1st, 2024 onwards. So while you're on probation, Ms. Bodie,
yes,
you are to have no violent contact with DeMaffiette Scott.
yes,
And you are to enroll and complete 4 anger management classes. These are weekly classes that you would have to enroll and pay for out of your own pocket. Once 4 classes are completed, your probation will terminate. So right now you have till the end of November with no probation fees to complete the classes. Otherwise, you need to make sure you get a job and start paying probation fees from December 1st onwards.
So do I go home today?
You will be released within 24 hours.
Thank you.
The bench warrant is null crossed. Okay, next case, please.
We're going to position number 45, Mr. Anthony Watts, position number 45.
Okay, Ms. Kim, good morning. What's the announcement for Mr. Watts?
How you doing, Your Honor?
I'm doing well. Good morning.
Your Honor, he's pleading guilty.
Okay, it'll be a plea. All right, thank you. Mr. Watts, your case number is 21 CR 7214A, in which you're accused of criminal trespass from April 24th of 2020. With regards to this case, you've been advised of your rights and your attorney is Ms. Kim. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Mokeke, what's the recommendation?
The state's recommendation is 12 months served, 20 days, credit for time served, 10 days, and that is from August 13th, 2024 to present. The balance is going to be suspended. There is a stay away from the Kids in Motion located at 7100 Peachtree, Dunwoody Road.
Ms. Kim, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
Mr. Watts, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood what's going on in your case?
Yes, Your Honor.
Are you satisfied with the legal services you received?
Yes, Your Honor.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial. You will not get the chance to confront your accuser, challenge the evidence that we brought before you, and have the state prove the case against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, Your Honor.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 20 days, credit for time served 10 days, balance suspended. Your jail time is concluded. You are to have, you're to stay away from 7100 Peachtree, Dunwoody Road. You have to stay 200 yards away from the business known as Kids in Motion. So if you are seen anywhere near that location, you'll be arrested again. So
Yes, I
let's
understand.
not have a repeat incident, okay?
Okay, no, ma'am.
Thank you.
All right.
ACDC, who do we have, please?
This is gonna be Ms. Huffman, number 17 through 18.
This is Selena Huffman, accused of willful obstruction of an officer under case 24 CR 23828. Ms. Huffman's also got a bench warrant, 24 FTA 1121. Ms. Huffman, you've been advised of your rights, and your attorney is going to be position 17. That would be Ms. Atay.
And this is a negotiated plea.
All right. Ms. Huffman, please sit up straight and raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
What?
If you don't want to respond,
I say yes. No. Go ahead.
Deputy Francois, does she know how this goes?
She got it this time, Judge.
Thank you. All right. And Ms. Falk, what is the recommendation?
Your Honor, the state's recommendation is time served. She has spent 18 days in jail, credit for time served 9 days.
Thank you. And Ms. Atay, do you stipulate to the factual basis, venue, and ID?
Yes.
Thank you. Ms. Huffman, have you consumed any medicine or alcohol?
No.
And have you understood what's going on in your case?
Yes.
Are you satisfied with your attorney?
Yes.
And has it been explained to you that if you plead guilty to this charge, you would have to give up your constitutional right to a trial? You will not get a chance to confront your accuser, challenge the evidence brought against you, present any defenses or arguments if you choose to do so, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes.
How do you plead to one count of willful obstruction of a law enforcement officer?
Guilty.
Your sentence is to serve 18 days, credit for time served 9 days. This closes out your case, and the bench warrant is now crossed. Thank you.
Next, we're gonna go to position 53, and that's gonna be Jarvis Woodard.
Mr. Jarvis Jermaine Woodard is accused of criminal trespass, simple battery against an officer, and a PI charge under case 24 CR 3594E. Incident date appears to be June 9th, 2024. Mr. Woodard, you've been advised of your rights, and your attorney is going to be Ms. Kim. And zooming on to, I'm sorry, Ms. Kim, I don't have your announcement. So what are we doing?
Negotiated plea, Your Honor.
Negotiated plea? Okay, thank you. Ms. Mokeke, I'm sorry, Mr. Woodard, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Mulcahy?
Yes, Your Honor. For count one, the state's recommendation is 12 months concurrent with count two. For count two, the state's recommendation is 12 months, serve 150 days, credit for time served 75 days. And that is from June 6, 2024 to present. Stay away from all MARTA locations and 8 weeks anger management. For count three, the state's recommendation is 12 months concurrent with count two. And I would ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
Yes, Your Honor, please.
All right. And Ms. Kim, do you know if your client has got a permanent ban from MARTA?
I believe,
This order will require him to stay away for up to 1 year.
okay. Yes, Your Honor.
All right. Mr. Woodard, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
You understand that you're agreeing to stay away from all MARTA property until further order of the court.
Yes, ma'am.
And if you decide to, and are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your constitutional right to have a trial. You will not go back to court and confront your accuser, challenge the evidence brought against you, present your defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the 3 misdemeanor charges against you, including criminal trespass and simple battery against an officer?
I'm guilty, ma'am.
Your sentence for counts 1 and counts 2 are going to run concurrent to count 1 and count 3 are going to run concurrent to count 2. Count 2, which is simple battery, is going to be sentenced as follows: 12 months to serve 150 days, credit for time served 75 days. Your jail time is concluded. If you have no other holds, you should be released within 24 hours. The remainder of the time will be served on probation. You will report to the probation office on Monday, August 26, 2024. Today is Thursday, so don't forget to report to probation on Monday. Do you understand, sir?
Yes, ma'am.
The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you are to enroll and complete 8 anger management classes. You must enroll in those classes within 60 days of being released. You're also to stay away from all MARTA property. No buses, no trains, no stations. You cannot even use the facilities at these MARTA stations, such as their restrooms and their parking. Do you understand?
Yes, ma'am. Yes,
Yeah, it
ma'am.
may be funny, but if you try to use the restroom, the next trip will be back to jail. So it won't be a laughing matter then, would it? But don't forget to, once you complete your anger management classes, Ms. Mulcahy, do you have any objection to non-reporting?
No, Your Honor.
All right. All right, Mr. Woodard, once you finish those 8 anger management classes, your probation will be non-reporting. So the sooner you're done with those classes, the better.
Yes, ma'am. 8 weeks. Yes, ma'am.
All right, thank you.
All right, take care.
Thank you.
Yes, ma'am. What's in the third row? Yeah.
This is gonna be number 32 through 36, Smith, Antoinette.
Thank you. All right. This is State versus Antoinette Smith. She's got 1, 2, 3, 4, 5 cases in front of us today. Let's begin with position 33, 23 CR 4505J. She's accused of battery family violence from July 18, 2023. Position 34 is 24 CR 5552J, in which she's accused of simple battery family violence, battery against a female who's pregnant, battery family violence, reckless conduct, and 1 more count of simple battery family violence from June 13th, 2024. She's got a bench warrant 24 FTA 1125 from July 8th, 2024. A second bench warrant 24 FTA 1126 from July 8th, 2024. 1, 2, 3, 4 matters. Ms. Smith, you've been advised of your rights and your attorney is Ms. Atay. With regards to these matters, how are we proceeding, Ms. Atay?
Your Honor, she's pleading not guilty to all cases and going to make a bond argument.
All right, let me just confirm. You'll be filing a waiver of arraignment for all these matters. All right, Ms. Smith, with respect to all these cases I've just indicated, your attorney is entering a not guilty plea and there will be further notice for a trial. All right, let's move forward with the bond argument. Go ahead, Ms. Atay.
Yes, Your Honor, she has lived in Georgia since she was 9 years old. She was working 2 jobs at McDonald's and Wendy's. She does have family and close ties to the community. She has been in custody now for 16 days. She does deny the allegations as stated in the warrants for the theft by taking allegedly a Ring camera. She denies that. The battery family violence, both cases are with the same complaining witness, and I believe that's why she has a $4,000 cash bond. But I spoke with the complaining witness and she states that she would want contact with her. She does not want her to be in jail. She wants the charges to be dropped. She states that she has not spoken with a victim advocate or anybody from the state. I'm not sure, but that's what she told me. And Your Honor, she denies the allegations and states that on both occasions, in both of the cases where she's charged with simple battery, that she's the one who called the police and the complaining witness was the first aggressor.
I'm not addressing the merits of the underlying offenses. She just didn't show up in court.
Yes, Your Honor, and she has.
Let's address that. Her attorney has withdrawn from the case and she didn't show up in court.
Yes, Your Honor, her mailing address in Odyssey is her mother's address, 766 Bender Street. She hasn't received any notice. So
I didn't.
She didn't receive any notice and she knows that that's a good mailing address at her mother's. And I didn't see any return to sender. I didn't see any.
There aren't any. I'm checking each and every case. Hang on. So the address I have, yeah.
I don't see notice at all.
Bender Street, is that the one?
Yes.
All right. Is there an apartment number?
No, it's a home.
Okay. Let's see. She lives at Bender Street or she receives mail at Bender Street? Which one is it?
Both.
Apparently her attorney withdrew from all these cases. I don't know whether there's been no communication between her and her counsel. And
I don't know.
Name isn't even listed anymore on the jailings. And she didn't show up and there's no return to sender. So I don't know what to tell you. That's Judge Besson's bond order for failure to appear in court.
Well, I don't see any, I don't see any mailing that it was mailed at all. I mean, if it was mailed, there would be a return to sender. If it wasn't delivered.
That argument works both ways, okay?
Sorry?
That argument works both ways.
So it can work in the favor of?
No, you're saying that if it was mailed, there should have been a return to sender. If it was mailed, there would not be a return to sender if it was delivered. I only have the defendant's assertion she did not receive notice.
Well, Your Honor, she didn't receive notice.
Okay.
Excuse me, Judge. Apparently, she had 2 active address on file. I'm looking at her, where the notices were mailed to. They were mailed to a 543 Oliver Street.
Yeah, that was the first
Northwest.
address.
And that was the active address. And then I see the other one that's in there on the Bend Street. So apparently, both addresses were active. The one that has the check mark with the check mark on it, that's shown as the current one. The 766 Bender is also in there, but it's not. If it doesn't have a check mark next to it, it won't. It will, that one for Oliver will override that Bender. So her notices were addressed to the Oliver Street and not to the Bender.
And I haven't spoken with her about Oliver Street, so I don't know anything about that address. If it,
But that has as the current address marked, but it also has the Bender, but that's not shown as her actual mailing address. So if it needs to be, it needs to be reversed in the system. I need to make the other one not active and make the other one active. So
We
which
got
one is going to
bunch
be?
of addresses on her. So, yeah. So what are we doing right now?
Your Honor, I mean, the FTA bonds are $4,000 each. I'm asking for her to have another chance to come to court with a good address on file. I don't know why there are 2 addresses. I don't know what the Oliver Street address is. I haven't been able to speak with her about that because
So I think this will be a good time to talk to her, confirm her actual mailing address, not multiple, her actual mailing address, and convey that to Miss Katrina Lewis and to our litigation. Miss Lewis, are you covering this calendar?
I'm the litigation today, and Miss Grace is the host.
Okay, so make sure you convey that. With regards to my other big question is, why has she not been in communication with her defense counsel, who actually withdrew from the case? So clearly, Miss Smith has dropped the ball on being diligent about these cases. I am going to amend the bonds, but I don't see where she's got a $12,001 bond. So it looks like the reckless conduct is $1.
Yes, and the other charges are $4,000 cash on each. And the battery family violence position 33, the bond order for that was a $3,000 good bond. She was ordered to have no further contact and to stay away. And then she had another incident on June 13th, 2024 with the same victim and her daughter. So she was in violation on June 2024 for that battery family violence. That's position 23 CR 004505J. And she's also in violation of her bond order for position 32 22 CR 008214J. She was ordered to stay away from the incident location and have no further contact with the victim, Deja Henson. She has been texting that victim as recently as July 2nd, 2024. And I would like to sound for all the victims, Miss Deja Henson, Miss Zakara Caslow, and Miss Rosenia Caslow, and also to bring to the court's attention that this defendant does have a pretty violent history, 5 arrest cycles in Florida, Georgia, 2013 conviction for battery, 2016 arrest for aggravated battery with a deadly weapon, 2015 arrest for battery in Florida. She also has a disorderly conduct that she pled nolo for in 2017, a willful obstruction that she pled nolo for in 2012. It is the defendant's responsibility to keep the court appraised of her address. She knows that she has 3 pending cases, so I would assume that she would have called the court and going on, make sure that her correct address is on file, especially since her attorney has withdrawn.
Mr. Tate, anything else to add?
Your Honor, I don't know why the attorney withdrew, but I think I know that she has a good mailing address and she has a phone number where she can be contacted. So I don't know. And I would just like to ask that the bond amounts be lowered as much as possible. The $4,000 failure to appear is for theft by taking of a Ring camera. And And then another, $4,000 for a failure to appear, first of all, is excessive. In addition, she has $1,000 cash bond on each of the recent misdemeanor, the 24 CR case, where I think at least it could be reduced to a surety bond.
The 24 CR case is against the same victim, and she was in violation of the 23 CR case when she committed the assault on that victim.
And that victim told me that
ladies, thank you very much. Thank you. The $4,000 surety bonds and the bench warrants are reduced to $1,000 surety each. The remaining bonds shall remain in place. And when she's before Judge Besson can enlighten her on why those cash bonds were instituted, and Judge Besson can enlighten her on what the reasons were for the withdrawal. But at the present time, I'm just going to issue $1,000 surety on the bench warrants.
On the bench warrants, not the Judge Besson didn't set the cash bonds.
The cash bonds were set by Judge Mincy.
Oh, that's fine. Leave it at that.
Judge, can you go over that again? So you're saying that her FTAs,
yeah,
her FTA is going to have $1,000 surety on each FTA?
Everything else remains the same. Let me
Okay.
go back to that screen. The failure to appear, there are two of them. They both have a $4,000 surety bond. And I'm going to amend that to $1,000 each. And I'm going to leave the other bond amounts the same.
Well, Your Honor, can we at least reduce it by $1,000? Because
No,
once they're merging, the state has offered to merge them. So at least $1,000 of that cash bond should be removed.
Mr. Tate?
They're merging counts, as you can see in the offer. So $1,000 of the cash bond, it's $1,000.
These bonds are a reflection of the defendant's conduct during the course of this litigation, and I'm going to leave it as it is. This is not Ms. Smith's first rodeo with litigation, and she is well aware that she needs to keep up with her court dates, make sure her address is correct and accurate. Ms. Smith, if you want to say something right now, you're going to incriminate yourself, but feel free.
No, you don't need to say anything. I'll speak with you later. I'm just asking that the $4,000 cash bond be $3,000, reflecting that the state intends to merge
Well, that was our plea offer, which was rejected.
I'm going to respect Judge Mincy's judgment in this matter and leave it as it is. Thank you.
Thank you.
Next case, please. And,
Your Honor, can we do Ms. McLeod's two cases she has, because she has to go to court?
you know, Deputy, you call the cases and and I'm at your disposal. So you tell me, you know, anytime. You can go to Ms. McLeod's cases, definitely. Okay.
All right, we're going to go to position 13 first, Mr. Quantavious Green.
This is Quantavious Green, accused of battery, 24 CR 5138G, from February 22nd, 2024. Mr. Green, you have been advised of your rights, and your attorney is Ms. McLeod. And Ms. McLeod, how are we proceeding?
Your Honor, this is supposed to be a negotiated plea. My client had pled to some other open cases that he had a few weeks ago, and my understanding is that the time that the state is asking in this case will run concurrent with what he has, so he will not have any extra time.
All right. Is that confirmed, Ms. Falk?
That is, Your Honor. I know that they're having some issues with time calculation over the jail on this case because he had a bunch of cases, and it looks like maybe he was bonded out before he bonded out on the other charges on another case. So we have agreed to reduce the 12 months to serve to 6 months to serve. That way, hopefully we're not butting up against it won't cause any additional issues other than what's already been caused.
So it's just 12 months to serve 51 days, credit for time.
6 months to serve, credit for time served 51 days, concurrent with the 23 CR 004422G.
So he does have additional jail time to complete before he's released.
Correct. He's already doing that jail time on the 23 CR case. The issue that they're having with calculation is on the 23 CR case. So we're just trying to make it so that this doesn't conflict with that.
Understood. Ms. McLeod, is that what your clients agreed to do?
Yes, Your Honor.
All right. Mr. Green, please rate. No, I haven't. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. And Ms. McLeod, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
And Your Honor, we just need to sound for Dawn Marie Harris if we can.
Sure. Ms. Harris?
Okay. It doesn't look like she is present.
Mr. Green, have you consumed any medicine or alcohol?
No, ma'am.
And have understood the proceedings in this present case?
Yes.
Are you satisfied with your legal services?
Yes.
And if you decide to plead guilty to this particular case, 24 CR 5138G, you would have to give up your constitutional right to a trial. You will not get a chance to go back to court to challenge this particular case, confront your accuser, present your defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
And how do you plead to this one count of battery from February 22nd, 2024?
Yes.
The sentence is going to be 12 months 12 months to serve 6 months, credit for time served 51 days. And this sentence will run concurrent with the sentence that was issued in case number 23 CR 004422G. Would that be accurate, Ms. McLeod?
Yes, Your Honor.
All right. Then that concludes the sentence. Thank you.
Thank you, Your Honor.
Next, Your Honor, we're going to go to medical, and that should be add-on 3, 4, and 5. And that's Mr. Maximilian Mack.
Three, 4, and 5. Okay. This is at medical. There he is. Okay. Gotcha. Thank you. This is State versus Maximilian Mack, accused of battery, family violence under case number 21 CR 813E. And incident date is February 19th, 2021. Mr. Mack also has a second case, 22 CR 004046E, accused of affray and obstruction from February 9th, 2021. And he's got a third case for a bench warrant, 24 FTA 1106 from November 7th, 2022. Mr. Mack, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. McLeod. Ms. McLeod, how are we moving forward with Mr. Mack's cases?
This is a negotiated plea this morning, Your Honor.
All right, thank you. Ms. Falk, what is the recommendation?
So, Your Honor, as to the first case, which is the battery family violence, the state's recommendation was, looks like, time served, the credit for time served, and we're also no processing the second case. So the credit for time served would be on the family violence case. It would be 13 days from February 19th of 2021 to March 3rd of 2021. On his second case, we would be on the affray, fighting, and obstruction of a law enforcement officer. That would actually be, it looks like on that FTA, he got 3 days from June 25th of 2022 to June 27th of 2022, and then from August 12th of 2024 until today. So that's going to be 14 days. And then on his last case, the FTA, it would be a null cross. The state would like to sound for the victim on the battery, which is Kesia Franklin, and we would like the defense to stipulate to venue factual basis and identification for the purposes of the plea.
I don't hear from a Franklin. Ms. McLeod, do you so stipulate?
Yes, Your Honor.
Ms. Falk, just to confirm on the battery family violence, position number 3 is to serve 26 days, credit for time served 13 days, correct?
That is correct.
And on the position number 4 is to serve 28 days, credit for time served 14 days.
That is correct.
Okay, thank you. Mr. Mack, if you could unmute, please. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Unfortunately, we have to unmute medical in order for me to hear Mr. Mack. Mr. Mack, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's going on in all your 3 cases?
Yes.
And are you satisfied with your legal services?
Yes.
And as your attorney explained to you, if you plead guilty to battery, family violence, affray, and obstruction of a law enforcement officer, you would be giving up your constitutional right to a trial in a court of law. You will not come back to court to confront your accuser, challenge the evidence brought against you, and have the prosecutor prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead? To battery, family violence?
Guilty.
Your sentence is to serve 26 days, credit for time served 13 days. Your case obligation for that case is over. How do you plead to affray and obstruction of a law enforcement officer?
Guilty.
Your sentence is to serve 28 days, credit for time served 14 days. Your obligation for this case is over. The bench warrant will be dismissed, and that concludes your cases. Thank you.
Thank you, Your Honor. And Your Honor, may I be excused until it's time for the competency calendar? I will log back on at that time.
I'll see you then. Thank you so much.
Thank you, Your Honor.
ACDC, who do we have, please?
Next, we're gonna do number 42, Ms. Velasquez.
Is this the one that requires a Spanish interpreter?
No, it's not.
All right, thank you. All right, this is Alejandra Velasquez, accused of reckless conduct and dog at large, 21 CR 004941E. Ms. Velasquez also has a bench warrant under 24 FTA 1136 from December 6, 2023. Ms. Velasquez, you've been advised of your rights and your attorney is Ms. Atay. Ms. Atay, how are we proceeding?
It's a negotiated plea, Your Honor, and she does want to do the community service hours rather than the fine, and I am asking for the 6 months of probation fees to be waived. I believe that that is necessary since she has been incarcerated for the last 8 months, so she does have a significant financial hardship, which requires probation fees to be waived.
Does she have any other holds besides these cases?
No.
Okay.
The only hold is the FTA.
Okay. Ms. Velasquez, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes, no?
Yes, Your Honor.
Thank you. Ms. Mokeke?
Yes, Your Honor. For count 1, the state's recommendation is 6 months probated, 10 hours of community service. For count 2, the state's recommendation is 6 months probated, concurrent with count 1, 25 hours community service, complete the animalscourts.com online course. And I would ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea. And of course, her FTA will be no cost.
All right. Okay, so she's been in custody in Fulton County for 13 days?
Yes, Your Honor, but she was transferred from Clayton County to Henry County to Fulton County.
All right, so Ms. Mokeke, are we giving her credit for 13 days?
Well, it's there's no time. The offer is just 6 months probation.
It was just 6 months probation.
Okay, no jail time then. Okay. And do you stipulate to the factual basis, venue, and ID?
Yes.
All right. Ms. Velasquez, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your two cases?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has it been explained to you that if you plead guilty to these charges, you would have to give up your constitutional right to a trial? You will
Yes.
not go back to court, confront your accuser, be able to challenge the evidence and present your defenses and arguments with the assistance of counsel, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
Will she be available for probation by Monday? Because
Yes,
I see she's got a hold.
I don't see a hold. I don't see a hold. And what's the hold?
Let me see. Jailing. Oh, that was from 2014. Sorry. Didn't see the date. All right. Sorry about that. Ms. Velasquez, how do you plead to reckless conduct, dog at large? Those are the two charges. How do you plead to them?
Guilty, ma'am.
All right. Your sentence is 6 months of probation. You will be released within 24 hours, and you must report to Fulton County Probation on Monday, August 26th before 3 p.m. The probation office is located at 132 Mitchell Street, Atlanta, Georgia. While you're on probation, you are to complete a total of 35 hours of voluntary community service for both these charges. It will be 10 hours for count 1 and 25 hours for count 2. You can do the community service at any nonprofit agency that is not a church, that is not a school, but you can do it at an animal rescue if you want to do so. All right? But any other place but a church or a school. And you are also required to complete an online course. It's called animalcourts.com. And that's one of the requirements. Once you complete the course, you'll need your certificate and produce that to your probation officer. Do you have any questions?
No, ma'am. Will I be getting all this information when I get out?
Yep.
Okay.
And
All right.
also from your probation officer when you report on Monday.
All right.
I'm going to waive your probation fees, but you'll be required to enroll in the animal court class within 60 days of being released. So within the next 2 months, you must enroll in that class and then make sure you show proof of enrollment within the next 60 days. And the community service, you have 35 hours to complete. I want you to do a minimum of 5 hours per month, beginning the first month, and a minimum of 5 hours every month thereafter. So you can't put everything off to the last minute. You need to get cracking on them right away.
Yes, ma'am.
Thank you.
Judge, let me get this clear. She's only gonna be on probation for 6 months for the total, both of these cases around the current, the charges?
They run concurrent, correct.
Okay.
All right, thank you.
Thank you. Judge, before you proceed in courtroom 2, I do have a quick announcement.
Yes, Francois?
Yes, is there any updates for our Spanish interpreter? For number 41?
1, 2, 3.
Let
No
me
one has
double check and
reported
see.
in.
Ms. Grace, can you check on that for me right quick, please? I
No
thought she'll
more-
be on, I thought she would be on by this time.
No, normally when she comes on, she lets us know, or he lets us know, so no updates yet.
Okay, and I also have another announcement for number 47, Brianna White. It's gonna be a reset. She went to downtown court.
Position 47 is reset, and let me see, 12 months of 60, credit for time 22 days. Who's the attorney, Ms. Kim? Are you representing?
I am, Your Honor.
That's Ms.
and
Hoda.
I would need her reset by Thursdays, SCP, next week.
Okay, so this will be a reset to August 29. Anything else, Deputy Francois?
And also
Honor-
for number, well, this is actually for the competency. I was told that we don't need to bring her.
That-
Position number 5, Ms. Grady.
Yeah, that will be fine.
Okay.
Your Honor, the reset that was reset to August 29th, what case was that?
Oh, Brianna White, position 47.
Got it. Okay, thank you.
Do you
Next,
read- Do we have any other cases at ACDC? Two more. Okay.
Yes, we do, Judge, but it's gonna be the interpreter case.
Okay, thank you. Courtroom
you.
2, Ms. Kim, who's your client?
This is gonna be position number 50.
50, okay?
Yep, Harold Williams.
Thank you. Right, let's see now. Okay. Mr. Harold Williams Jr., case number 21 CR 5953J, has got 3 misdemeanor offenses stemming from a traffic incident. He's accused of reckless driving, fleeing and attempting to elude an officer, and driving while license suspended or revoked. Mr. Williams, you've been advised of your rights. Your attorney is Ms. Kim. And Ms. Kim, how are we proceeding?
Not guilty, Your Honor.
All right.
I will file a waiver of arraignment.
All right. Mr. Williams, your attorney is going to file a waiver of arraignment and enter a not guilty plea. Your case is going to be further noticed for trial. And with regards to Mr. Williams, I gather, since this is from 2019, yeah.
Your Honor, as of now, he does not have a bond for these 3 charges. Can he please get a bond?
Okay. Pre-trial, do you have Mr. Williams GCIC?
Yes, Your Honor. Good morning.
Morning.
Let's see. We have 25 arrest cycles beginning in 2003. His previous arrest was in Union City, May 23rd of 2022. That was for purchase, possession, manufacture, distribution, or sale of marijuana. That case was dismissed July 8th of 2024. He has a misdemeanor conviction out of Fulton County for pointing or aiming gun or pistol at another, 2 counts. That's from, excuse me, August of 2021. He has another misdemeanor conviction for marijuana possession less than 1 ounce out of Fayette County from 2016. He has another marijuana possession less than 1 ounce in a reckless conduct from 2015 out of Fayette County. Took a NOLO plea on that case. Let's see, and he has an FTA from 2 from 2019. And then 1 from 2013, Your Honor. Nothing to add.
Thank you.
Mhm.
And Ms. Mokeke, do you have a bond recommendation? He currently has a, well, for at least the misdemeanor cases, he's got a $6,000 surety bond.
Yes, Your Honor. I'm not sure if Krishan mentioned, but he also has a 2024 arrest for possession of a sawed-off shotgun, a 2024 FTA, and a 2024 probation violation. In this instance, he was at a checkpoint. The officer smelled marijuana, asked him for his license, then asked him to pull into the staging area. He acted like he was pulling in towards the staging area and then accelerated and fled the scene. He was driving at a high speed, veering from lane to lane. And then, of course, he has 3 active license suspensions for failure to pay child support. The last one was in 2017. The state's recommendation is going to be a $1,500 surety bond for the reckless driving, $1,500 surety bond for fleeing or attempting to elude an officer, and a $500 surety bond for driving while license suspended or revoked. Of course, no driving without a valid license or insurance.
All right. Miss Kim?
Yes, Your Honor. He has actually 17 children, Your Honor. 9 girls are actually living with him because their mother is moved to another country. So she was arrested in another country. He's the only one who's supporting 9 minor girls right now. And he does have to get out to take care of those people. And right now, apparently somebody else was driving his car, and the car was registered in his name. So he's responsible. He was not even arrested. He didn't even know there was any kind of bond, and he didn't know that there was any court appearance because he didn't get any notice. So we would like to request for a signature on bond through pre-trial level 3, and hopefully, yeah, and this is really old case, 2019. So that's what we would like to ask for.
Yes,
And
rather, it's a little dated case, but Mr. Williams hasn't exactly kept his nose clean since then. Each count is going to be $1,000 surety. The total bond is going to be a $3,000 surety bond. No driving unless he has a valid driver's license, adequate insurance, and proper registration. Mr. Williams, I don't know if your license is valid, but if you want to run the risk of driving while your license is not valid, then that's up to you. You are not to consume any illegal drugs and no alcohol, and not possess any weapons or any firearms. And within 7 days of being released, you are to come down to the clerk's office and provide your valid mailing address to the clerk in writing. Thank you.
Thank you very much, Your Honor.
You do know that he's not going to be released right away because of that felony charge. Okay.
You do know.
You can go to jail court's iPhone next, y'all.
All right, thank you. All right, who do we have there, please? Jail court iPhone. Deputy, good morning.
Yeah, position number 12, Mr. Flannery.
Thank you, sir. This is Londi Flannery.
You got jokes.
Yes, ma'am.
Ms. Lewis, please unmute. Thank you. Mr. Flannery's case is 24 CR 5563J, accused of 2 counts of simple battery from July 1st, 2024. Mr. Flannery, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Atay. Ms. Atay, this is still going to be a negotiated plea?
Yes, Your Honor. And I am going to ask for probation fees to be waived because he has been in custody since July 10th. Not in Fulton County, but in Clayton County.
Understood. Mr. Flannery, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what's the recommendation?
Yes, Your Honor. State's recommendation is 12 months served 30 days, credit for time served 15 days. That's from August 8th, 2024 to today. Balance probated. No further contact with Shatara Pease. 8 weeks of anger management. Count 2 will merge with count 1. We would like to sound for Ms. Shatara Pease at this time, and we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
Stipulate, Your Honor.
All right. I don't see a Shatara Pease on Zoom. So, Mr. Flannery, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am, I am.
And has it been explained to you that if you enter this plea, you would have to do so by waiving your constitutional rights to a trial? You will not get the opportunity to go back to court, confront your accuser, get a chance to challenge the evidence brought against you, have the assistance of counsel to aid you in presenting your defenses and arguments, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, I am.
How do you plead to 1 count of simple battery?
Yes, ma'am.
How do you?
I plead guilty. I plead guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served 15 days. If you have no other holds, you'll be released within 24 hours. Does he have any holds, Ms. Atay?
Not that I see.
Okay. If he has no other holds, then he's required to report to probation on Monday, August 26th before 3 p.m. While on probation, he is to complete 8 anger management classes. I'm going to waive probation fees up to and including through the end of November 2024. And then after that, from December 1st, 2024, he'll need to start paying probation fees. Yes, sir?
Can you run that back? It's kind of loud in the background. I couldn't hear what you said. I was like strong with the court date, strong with after reporting on Monday. I didn't hear what you said.
You have to report to probation on Monday, August 26th before 3 p.m. While on probation, you have to complete 8 anger management classes. You report to probation every month. Your probation fees shall be waived up to November 30th, 2024. And if you complete your anger management classes but before the end of by November 30th, then your probation will be non-reporting. Count 2 will merge into count 1.
Thank you, Judge.
Mhm. All right, let's mute jail court iPhone, and we are in courtroom 2.
And this is going to be position 22 and position 23, Mr. Kimon Jackson.
Mr. Kenneth Jackson.
No, Kimon Jackson.
Kimon Jackson. Okay, sorry, 22 and 23. Okay, thank you. Position 22 is Kimon Deshaun Jackson, accused of criminal trespass under 22 CR 3880E from July 20th, 2021. His second case is 22 CR 3882E, in which he's accused of simple battery and criminal trespass causing damage to property from March 15, 2022. Mr. Jackson, you've been advised of your right to remain silent, and your attorney is Mr. Tom White. Mr. White, how are we proceeding?
It's a negotiated plea, Judge.
Mr. Kimon Jackson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Poe?
Yes, Your Honor. On the criminal trespass, the state's recommendation is 12 months with 162 days to serve, credit for time served 81 days. That's going to be from June 17th to June 19th of 2022 and June 6th, 2024 to today. Balance probated $1,000 in restitution to Latasha Gray, aka Angelique Reddick. Stay away from 132 Linkwood Drive Northwest, as well as no further contact with Latasha Gray, aka Angelique Reddick, 40 hours of community service, and no firearms. This is a global recommendation with the next case on the calendar, which is simple battery, criminal trespass, and damage to property. That is the same recommendation as above, with the change of a $200 restitution instead of $1,000. So that's going to be a total of $1,200 in restitution. We also on count 2 are asking for 12 months concurrent with count 1. The state does ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We would like to sound for Latasha Gay, aka Angelique Reddick.
Stipulate, Judge.
Latasha Gray, Angelique Reddick. All right. Mr. Jackson, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's going on in your 2 cases?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And has it been explained to you that you would have to give up your constitutional right to a trial in front of a judge or a jury? You will not get the chance to go back to court to confront your accuser, challenge the evidence that we brought against you, present your own defenses and arguments, as well as have the state carry its burden and prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to criminal trespass from July 20th, 2021?
Guilty, ma'am.
How do you plead to simple battery and criminal trespass causing damage to property from March 15th, 2022?
Guilty.
For the criminal trespass in 2021, your sentence is 12 months to serve 162 days. Credit for time served 81 days. The remainder of the time you'll be on probation. Once you're released, you must report to probation on Monday, August 26, 2024, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you are to complete 40 hours of community service with any nonprofit agency that's not a church and not a school. and not be in possession of any firearms. You must begin your first month of probation with completing at least 5 hours of community service and a minimum of 5 hours every month thereafter. For the 2021 charge of criminal trespass, you're also required to pay $1,000 in restitution to Miss Latasha Gray, also known as Angelique Reddick, and you'll be required to pay a minimum of $200 in the first month and $200 every month thereafter. With regards to the second case, how do you plead to simple battery and criminal trespass causing damage to property?
Guilty.
Your sentence is going to be concurrent to the first case, and it's 12 months to serve 162 days, credit for time served 81 days. The 40 hours community service and so forth are all concurrent, with the addition of a $200 restitution to Angelique Reddick, also known as Latasha Gray. And for this additional $200, you must pay a minimum of $50. So every month thereafter. So in total, you need to pay $250 every month until these restitution amounts are completed. Do you understand?
Ma'am.
All right.
We'd ask that you waive the probation fees.
I will waive from all probation fees as long as he complies with the minimum payments for restitution every month.
Thank you, Judge.
Mhm.
Your Honor, I did
Miss-
admit that on positions 1 and 2, the defendant had, on the add-on SAP calendar, the defendant had 2 FTAs. The state has sent the null pros orders on those 2 FTAs.
Okay. Position 1 and 2 are null cross. Thank you. All right. Jail code iPhone, shall we address your case?
Yeah, we have positions 48 and 49, Mr. White.
This is State versus Tyrone White, case number 24CR5585C, accused of battery, family violence from September 11, 2023, and an additional battery charge under 24CR5586C from August 9th, 2024. Mr. Tyrone White, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Kim. Ms. Kim, how are we proceeding on Mr. White's case?
Negotiated plea, guilty. I just want to know if we can waive a probation fee for the first 3 months, since he does not have a job right now.
All right, I'll see. Mr. White, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
All right. Can you hear me all right?
Trying my best.
Try to come as close as possible to the phone. I really can't scream into the Zoom. All right. Ms. Mokeke, what's the recommendation?
The recommendation for position 48 is 12 months served, 90 days, credit for time served, 14 days, balance probated, no further violent contact with Shaquante Arnold, no firearms in an FVIP course. That is, of course, a global recommendation with position 49, which is 12 months served, 90 days, balance probated, no further violent contact with Alquisha Logan Smith, no firearms. We have spoken with both victims and they do agree with the plea offers, and I would ask the court to sound for them as well as ask the defense to stipulate to venue factual basis and identification for purposes of the plea.
Ms. Kim, do you so agree?
Yes, Your Honor.
All right. Ms. Lewis, I believe an Alquisha or an A. Smith was in the waiting room. Is she still there?
I don't think so. Nope, she logged off.
All right. And is there a Shaquinic Miss Arnold? All right. Mr. White, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your two cases? If you can't hear me, you need to say, I cannot hear you. Have you understood what's going on in your two cases?
Yeah.
And are you satisfied with your attorney?
Yes, ma'am. Very satisfied.
And has she explained to you that if you enter these pleas, you would be giving up your constitutional right to a trial? You will not go back to court. You will not confront your accuser. You will not be able to challenge the evidence brought against you and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, she has.
How do you plead to one count of battery, family violence with regards to Shaquinita Arnold?
Guilty.
How do you plead to one count of battery with regards to Alkeisha Logan Smith?
Guilty.
With regards to position 48, your sentence is 12 months to serve 90 days. Credit for time served 14 days. You have additional time to serve at the jail. Once you are released, you are to report to probation on the first business day on a Monday, Tuesday, or Thursday, and probation is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will enroll in a domestic violence intervention program within 60 days of being released. And you are to complete all 24 weeks of those classes at your expense. If you fail to enroll and start those classes, you will be rearrested again for a probation violation. Do you understand?
I do.
You are to have no contact with Alkeisha Arnold, and you're not allowed to own any firearms.
I do.
With regards to the second case, the same, it will be concurrent, 12 months to serve 90 days, credit for time served 14 days. You will also be on probation for that case. In that matter, you are to have no further violent contact with Alkeisha Logan Smith and no firearms.
Yes.
All right.
Just for clarification, Your Honor, for position 48, did you say that was no further contact or no further violent contact?
Oh,
The recommendation.
I said no further contact. Is it no violent contact?
Yes, Your Honor.
All right, my bad. It is no further violent contact with the two victims.
Okay, so that means just don't go around them, right?
No, it just means that if you talk to them or you're near them, there cannot be any physical or verbal altercations. If there are any fights or arguments and the police get involved, you are back in jail.
Okay.
So if you don't think you can
I don't want no contact.
Then stay away from them. That's entirely up to you.
Okay. All right.
Thank you.
All right.
Oh, I'm sorry, Miss Kim, I'm going to waive probation fees for the first 2 months upon his release.
Thank you, Your Honor.
I'm sorry, Judge. What are you gonna waive the probation fees on how many
The
months?
first 2 months upon his release, he's got additional time to serve at the jail.
And I know this is not a question of record. Mr. Jordan wanna know, are you presiding over today, SEA Gowner?
No, that would be not me.
Okay.
You can go to medical, Your Honor.
Yes.
Position number. Position number 14, Mr. Guthrie.
Okay. My goodness, position 14. Miss Lewis, Judge Williams will be covering the C calendar, FYI.
Okay, and also FYI, we are not gonna have an interpreter.
Okay. Is Deputy Francois still available at ACDC? Or if you can send her an email, Miss Lewis.
I put it in a text. I'm in a chat to everyone. I don't know if she read it
It
or
might
not.
not be at the screen. That's the only thing. Okay. All right. Brendan Guthrie is charged with battery under case 24 CR 5580C. Mr. Guthrie, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Mr. Tom White. Mr. White, this is going to be a negotiated plea. Mr. Guthrie, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Thank you. Ms. Bell, what's the recommendation?
Yes, Your Honor. On Mr. Guthrie, it's 12 months, served 30 days, credit for time served 15 days. That's from August 8th, 2024 to today, balance probated, no further contact with Pravin Rotman, ADET, and stay away from 470 Liberty Trace and 260 West Spalding Drive. We do ask the defendant to stipulate to venue, factual basis, and identification for the purposes of the plea. We would like to sound for Pravin Rotman.
All right. I do see Mr. Rutnam is available. And Mr. White, do you stipulate to the factual basis, venue, and ID?
We do, Judge.
All right. And Mr. Rutnam, did you want to chime in?
Yes, please.
All right. Mr. Rutnam, this will require him to have no contact with you for at least up to 1 year. And he'll need to stay away from that treatment facility at I think it was at Liberty Trace, as well as your location in West Spalding. Would that be accurate?
Yes.
All right. And do you have any other comments?
Yeah. Is there a way to make him give a statement on what he did during that day, that he attacked me and it's not an altercation, or I don't know, how does it work, in terms of?
All right. Please hold. Mr. White, would Mr. Guthrie like to allocute anything?
Your Honor, I think the guilty plea speaks for itself.
All right. Medical, please unmute.
Legal.
Mr. Guthrie, you have a right to remain silent. Anything you choose to say can and will be used against you, even for sentencing. But if you want to waive your right to remain silent, you can consult with your attorney if you want to say anything.
I would just like to say that Praveen was also arrested in the exact same incident.
Listen, I would not say anything. If you just want to go forward with this and get it behind you, then let's
All
just.
right. So, Mr. Rutnam, thank you, Mr. White. Mr. Rutnam, there's going to be no allocution at this time from the defendant.
Okay.
Anything else, Mr. Rutnam?
I guess I don't know what else to say. I guess.
All right, then please mute your screen. Thank you. Mr. Guthrie, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood what's been going on in your case?
Yes, Your Honor.
And are you satisfied with your legal services?
Yes, I am.
And has it been explained to you that if you decide to plead guilty to this one count of battery, that you would be giving up your constitutional right to have a trial in your particular case? You will not have the opportunity to go back to court with your attorney to confront your accuser, challenge the evidence that would be brought before you, have the assistance of counsel to present any defenses or arguments you may have, and also to have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
Are you entering this plea freely, willingly, and knowingly?
Yes, I am.
All right. How do you plead to the one count of battery?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served 15 days. Your jail time is concluded, but you will be, the remainder of the time will be on probation. You will report to the probation office on Monday, August 26th before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will enroll in an alcohol and drug evaluation and submit yourself to any treatment that's required. And this must be done within 30 days of being released, so that by your second probation visit, you will confirm with probation that you have undergone that evaluation and the status of the treatment. You are also to have no contact with Praveen Ratna. You're to stay 200 yards away from him and not communicate with him in any way, form, or manner, including in person, mail, email, third parties, electronic devices, and even on social media. If you violate this condition, your probation could be revoked. In that stream, you're also required to stay 200 yards away from 470 Liberty Trace in Roswell and 200 yards away from 260 West Spalding Drive. I can't recall whether that was in Atlanta or Sandy Springs. You are to report to probation every month. I'm going to require you to submit to random screens for alcohol and illegal drugs. You're not allowed to consume any alcohol and illegal drugs while you are on active probation. Do you understand, sir?
I do.
All right. Anything else, Mr. White?
Judge, the screens weren't part of the negotiated plea. He's already doing an alcohol drug evaluation. That seems like, I
Mr.
understand.
White, I am familiar with this case, and I think it would be most beneficial for Mr. Guthrie to submit to random screens.
Okay.
So if you don't want me to impose this, then we are going to reset this case for trial.
Judge, we'll go ahead and go with the random screens.
Mr. Guthrie, do you have any objection to the random screens?
I do not.
Right, that will be the sentence. Thank you.
Judge Law, what is the report time for Monday?
A report date is August 26th, before 3 p.m.
Before 3? Okay.
Thank you. Mr. Ratnam, you're free to go. And Deputy Francois, we will not be able to secure an interpreter today. This is with regards to, is that the add-on case?
Actually, he's on both calendars. He's on the regular calendar, number 41, and also on the add-on number, let's see, number 6.
Okay. Is that Miss Kim's client?
It's my client, Your Honor.
Miss Atay, we are unable to secure an interpreter today. I can reset it for next Tuesday or next Thursday.
Well, I think next Tuesday is better.
Okay. Miss Lewis, we're gonna have to squeeze in Mr. Valadares' case. He is position 6 on the add-on and position 41. And it will be a reset to August 27. Let's be sure to get the interpreter. Deputy Francois, would you be able to communicate that to him?
A poquito.
Mr. White, how's the Spanish?
Did you say Mr. White?
Yeah. How's your Spanish?
No habla.
Is anyone, Miss Falk, Miss Mokeki?
What are you trying to communicate exactly?
His case will be addressed on August 27, Tuesday, where a Spanish interpreter will be available. Folks, I'm from the Far East. I didn't learn Spanish.
You could type it in Google and have it translate, or type it in some
I
way. And
don't know if this
translate
is
it.
correct, but it says su caso será manejado el 27 de agosto, 27 de agosto.
He said perfecto. Thank you.
That worked. Thank you, Ms. Paul. Okay.
Not a problem.
All right. Deputy Francois, that his cases are reset. Anything else?
That's it. Thank you. We're completed. Thank you, Judge Law.
Thank you. Have a good one.
You too.
Deputy Norris, am I going to courtroom 2 or jail court iPhone?
Courtroom 2, then jail courts.
All right, sir. Mr. White, who do you have?
This position 30, Curtis Robinson.
30 and 31.
30 and 31.
30 and 31. This is Curtis Robinson. Case 23 CR 6863D, accused of criminal trespass from November 2nd, 2023. And he's got a bench warrant under 24 FTA 1112 from January 4th, 2024. Mr. Robinson, you have been advised of your rights and your attorney is Mr. White. Mr. White, will this be a negotiated plea?
Yes, Judge.
Mr. Robinson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Please speak up, sir.
Yes, yes.
Thank you. Ms. Mokeke, what's the recommendation?
The state's recommendation is time served, 30 days, credit for time served, 15 days. And of course, no crossing that FTA.
Mr. White, do you stipulate to the factual basis, venue, and ID?
We do, Judge.
Mr. Robinson, have you consumed any medicine or alcohol?
No, ma'am.
And are you satisfied with your legal services?
Yes.
Has it been explained to you that if you plead guilty to criminal trespass, you will not get a chance to have a trial? You will not
Yes.
go back to court, confront your accuser, challenge the evidence, and the prosecutor won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes.
How do you plead to one count of criminal trespass?
Guilty.
Your sentence is to serve 30 days, credit for time served 15 days. Your jail time is concluded. The bench warrant is dismissed, and you'll be released within 24 hours. Thank you.
Thank you, Your Honor.
Jail court items, do we have?
We have positions 39 and 40, gentlemen.
This is State versus Mr. First name begins with a Z. Last name is Tillman. Are you Mr. Tillman? You need to speak up, okay? Are you Mr. Tillman?
Yes, ma'am.
Thank you. Mr. Tillman, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your attorney is going to be Ms. Kim. Mr. Tillman's case is 19 CR 6960F, in which he's accused of simple assault, family violence, reckless conduct, and obstruction of a law enforcement officer. And he's got a bench warrant under 24 FTA 1123 from December 9th, 2022. Ms. Kim, how are we proceeding?
Not guilty, Your Honor.
All right. Mr. Tillman is, your attorney is going to file a waiver of arraignment and enter a not guilty plea, and your case is going to be further notice for trial. Anything else to address, Ms. Kim?
May we please reduce the bond from 7,500 to lower bond? He has been in jail for the last 12 days, Your Honor, and also he's only 30 years old. He lost a job. He graduated from high school. He needs to start his life altogether. We would like to request for a lower bond.
All right. Ms. Mokeke, any issues with the request for a modification of bond?
We would object to the modification of the bond. In this case, the defendant fired a rifle in the air at an apartment complex and also ransacked the victim's apartment and broke several objects in that apartment. This $7,500 surety bond looks like it was signed by you, Judge Law. The defendant also has arrest cycles in multiple states, 2 in Georgia, 2 in Alabama, 1 arrest cycle in South Carolina. So we would ask that the bond remained as it is.
Ms. Kim, any particular reason why Mr. Tillman was MIA on December 9, 2022?
Actually, that I do not have any answer, Your Honor.
All right, we'll keep the bond as it is. Thank you.
Thank you.
All right, moving on.
If jail court's iPhone has somebody else,
Well, I gotta go up to 5 stop. Give me about 10 minutes. I'll grab it.
Okay, 10 minutes. That's okay. And courtroom 2, if you don't have anyone, I can go into my breakout for the 11 o'clock calendar. Oh, we have someone at medical.
We have somebody in medical.
Okay, who do we have?
Position number 38.
That's Kim.
38.
This is State versus Jonathan Marcus Taylor, accused of simple battery, family violence, and battery, family violence from November 6, 2022. Mr. Taylor, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Kim. Ms. Kim, with regards to Mr. Taylor, how are we proceeding?
Actually, if the family violence interference program, if he does not have to take the class, he's willing to take the entire deal, Your Honor. So we would like to know if we can just remove that and then follow everything else.
Has he taken the class before?
No, Your Honor.
All right. Ms. Mokeke, this is these two are family violence charges. What's the state's position? I'm sorry, Ms. Mokeke, you're on mute.
I apologize. The state is not agreeable to removing the FVIP. It's statutory per OCGA 1913-16. He also has a 2020 arrest for simple battery out of Florida. And in this instance, he is accused of punching his sister, causing swelling to her eye, and also punching his mother multiple times in various parts of her body.
Let's see now.
In that case, we have to plead not guilty, Your Honor, because he could not do that. Thank you.
Mr. Taylor, the prosecution is, and the court is not going to dispense with the domestic violence program. This is mandatory by law, where you are, if you want to plead guilty to a family violence criminal charge. Your attorney has indicated then that she will file a not guilty plea on your behalf, and the case will be reset for trial.
Okay, ma'am.
All right. Can you go ahead and file the waiver of arraignment, and the case is further noticed for trial.
Thank you.
I have an announcement. Position number 46, Mr. Webb, he refusing to come out.
Mr. Webb, and who is the attorney?
Position 46.
46. Is he outside the door, or is he just refusing?
He's in his housing unit. I've been to get this guy twice, and every time I go get him, he go to his cell. So I'm not gonna keep fighting with him.
Is that Mr. White or Mr. Kim's client?
He's my client, Your Honor.
I can reset him to August 29th.
Can it be a little bit earlier, 27? Do we have a room?
It would be time served, balance suspended today, but he's refusing to come out, and I cannot bring him, you know, that old adage about you can't bring the horse to the water.
Okay.
All right, Mr. Webb's case is reset to August 29th, and hopefully he'll feel a little better then. Thank you. All right,
Okay, Your Honor, we're going to go to position number 24, Mr. Jeffrey Ladd.
Mr. Haddad, did you have a separate case?
No, Judge, I'm covering for Mr. Bartels for the 11 o'clock.
Oh, I appreciate it. Okay, thank you. As soon as
I'm here, Judge.
appreciate it. Thank you.
Take your time.
All right. No, don't tell me you do that. Okay. Jeffrey Ladd is position 24, accused of driving under the influence of alcohol less safe and reckless driving from July 31st, 2018. Mr. Ladd, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. Mr. Tom White will be representing you. And Mr. White,
This is going to be a plea, Judge. This one I wasn't able to speak to until this morning, so.
All right. Mr. Ladd, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what is the recommendation?
Yes, Your Honor. State's recommendation is 12 months served, 16 days, credit for time served 8 days. That's from August 15th, 2024 to today. Balance probated, $600 fine, DUI risk reduction, ADET, victim impact panel, 40 hours of community service, and count 2 will merge with count 1. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
We stipulate.
Mr. Ladd, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings in your case?
I do understand.
Are you satisfied with your legal services?
Yes, I am.
And has it been explained to you that if you plead guilty to DUI today, although the arrest was from 2018, that your license will be suspended?
License will be suspended. I haven't drank in 6 years, ma'am. Since that night.
Oh, no, that's not something within my control. Upon the entry of a guilty plea to DUI today, your license will be suspended and you will be eligible for reinstatement after 120 days.
Okay, I understand. I'm okay with that, ma'am. I understand.
All right. And has it been explained to you that if you enter this plea, you would have to give up your constitutional right to a trial? You will not get the opportunity to go back to court, to confront your accuser, challenge the evidence that's brought against you, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of driving under the influence of alcohol less safe?
Guilty.
Your sentence is going to be 12 months to serve 16 days, credit for time served 8 days. The remainder of the time will be served on probation. You will report to the probation office on Monday, August 26, before 3 p.m., and the office is at 132 Mitchell Street in downtown Atlanta. While you are on probation, you will complete the following: pay a $600 fine, complete a risk reduction class, which you must enroll within 60 days of being released. You will complete an alcohol and drug evaluation and submit to any treatment if required, and this evaluation must be done within 30 days of being released. You will attend and complete a victim impact panel, finish 40 hours of voluntary community service with any nonprofit agency that's not a church and not a school. You must start with a minimum of 5 hours per month and complete a minimum of 5 hours every month with regards to community service. With regards to your fine, you must start paying a $50 towards every month, with a minimum payment of $50 every month and a minimum of $50 every month thereafter. I will waive your probation fees for the first 2 months up to the end of November 2024, and you will start paying probation fees from December 1st, 2024 onwards. Yes, sir?
I would ask that you waive the entire amount of probation fees. He is unemployed, has no prospects for a job at this time. Additionally, all that he is required to do under this is quite onerous. By the time they add on court costs and surcharges to a $600 fine, it's probably going to be closer to 11 or 12.
Okay.
Plus he has to pay for the school, the ADT. So
I will waive it for up to 6 months, 6 months of probation fees, because he's eligible for reinstatement in 4 months. Then he can get his license and hopefully be able to secure some kind of employment.
Okay.
All right, anything else? That's it. Thank you.
Yeah.
Deputy, do you have any cases to address? Otherwise, I can go into my breakout.
No, we have a few more, Your Honor.
All right, keep me busy.
All right. Position number 21, Mr. Kenneth Jackson.
Yes, sir. Mr. Kenneth Jackson's case is 24 CR 5567C, accused of reckless conduct and willful obstruction of an officer from August 8th, 2024. Mr. Jackson, you have been advised of your rights and your attorney is Mr. White. Mr. White, how are we proceeding?
Be a negotiated plea, Judge.
Please raise your right hand, Mr. Kenneth Jackson. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do, Your Honor.
Thank you. Ms. Falk, what's the recommendation?
State's recommendation is 12 months. On count one is actually time served, 30 days, credit for time served, 15 days from August 8th, 2024 until today. On count two, the recommendation is 12 months served, 30 days, credit for time served, 15 days, August 8th, 2024, concurrent with count one, stay away from Rain, located at 1021 Peachtree Street Northeast in Atlanta. So that will be a balance suspended. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. And that's all for the state.
Mr. White, do you so stipulate?
We stipulated, Your Honor.
Okay. Mr. Jackson, have you consumed any medicine or alcohol?
Yes, Your Honor.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And has it been explained to you that if you decide to plead guilty, you would have to give up your constitutional right to a trial? You will not get an opportunity to go back to court to challenge the evidence brought against you, confront the accusers in this case, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, Your Honor.
Mr. White, does he still have a felony hold?
Not that I'm aware of, Judge. I've got a note next to this that says no other cases, so.
I have 24 PI 2796. This is the allegation of where he allegedly tried to start a fire at a street intersection. Ms. Lewis, can you confirm?
Kenneth Jackson.
Yes, give me 1 second. I'm looking at it now.
Your Honor, I believe that the 24 PI case that you're seeing, I think, was the case that became our case. It was actually, I believe, transferred to state court, which is how we got it. I just want to double check and make sure I'm correct on that information.
That's our understanding as well, Judge.
Okay. I just want to be sure that if I tell him he's going to be released within 24 hours, that he is. So,
and Your Honor,
Two different
I'm
dates.
here at the 24 PI case, and let's see. There was a first appearance order for bond where he was given a UJR bond on April 22nd of 2024. And then there was, okay, so I'm not allowed to view that document. There, Your Honor, I may have a moment. So while you're handling his plea, let me just take a look at the wording of my accusation, because I'm pretty sure this was the transfer.
okay. And Mr. Jackson, as I was saying, if you decide to plead guilty to this charge of willful obstruction and reckless conduct, you would be giving up your constitutional right to a trial where you will not get a chance to challenge the evidence, confront your accuser, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am, Your Honor.
How do you plead to reckless conduct and willful obstruction of an officer?
Guilty.
Your sentence for the count one, willful obstruction, is going to be to serve 30 days, credit for time served 15 days. For the reckless conduct, the sentence is going to be 12 months to serve 30 days, credit for time served 15 days, balance suspended. However, you cannot return to that location where this incident took place, which is called Rain, and that's located at 1021 Peachtree Street in Northeast Atlanta. Do you understand, sir?
Yes, I do, Your Honor.
All right. Don't play with fire. Thank you.
So Your Honor is correct. The 24 PI case is a different case than our case. But he was given a UJR on that case.
All right. No holds then. Thank you.
Yep.
Courtroom 2. Oh, I have jail court iPhone.
Yes. Quick announcement, positions number 1 and 2, Mr. Aarons. He's no longer on this floor. He got moved off and I'm not sure where he went.
Oh my. Miss Atay, is that your case?
See, LIJ, 1 and 2, he's not on the same floor anymore. They don't know where he is.
Yes, position 1 and 2, Aaron Durrell, that's my client, or Durrell Aaron. He was at Grady yesterday. I don't know where he is. I haven't been able to speak.
All right, I am going to reset him to August 29. And the 12 months.
Well, Your Honor,
I can't squeeze it in on 227.
then we need to find him today. If he's not at Grady.
Or signature bond on a 3-year-old.
To verify.
Or converting whatever's holding him here to a signature bond.
Miss Lewis, what's the calendar like for next Tuesday?
It's already produced, Judge. It's overflowing.
It's overflowing. I'm going to reset it to August 29, unless he's produced before the end of this calendar. Okay.
We're talking about position number 1.
1 and 2.
Okay. I mean, he has felony holds on him, so I'm just letting you know. I don't know if you saw that or not.
No, I didn't. I'm not looking at that right now.
Okay, like I said, I'm going to reset it to August 29 unless he's produced before the end of this calendar. Okay, moving on. I'm so sorry. Who do you have next to you at jail?
Position number 8, Mr. Broughton.
J8, okay. And that is Levonta Broughton, accused of criminal trespass causing damage to property from September 28, 2023. Accusation 24 CR 5576J. Mr. Broughton, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is going to be Ms. Atay. Ms. Atay, this is going to be a waiver of arraignment?
Yes, Your Honor.
Mr. Broughton, your attorney is entering a not guilty plea on your behalf, and your case is going to be further noticed for trial. Anything else? Anything else, Ms. Atay?
Nothing else.
All right.
What position was this?
Position 8. Yes, Mr. Broughton?
No, I ain't said that. I said I don't want to waive my opinion.
That's not what this.
Your attorney has, I'm sorry, go ahead, Ms. Atay.
You're not waiving your appearance. You're
You're
here. We are waiving the arraignment, unless you don't want that.
Yeah.
Do you want me to arraign him, Ms. Atay?
Yes, ma'am.
Yes, you can arraign him then.
And Mr. Broughton? All right. And Ms. Atay, do you waive a reading of the accusation?
Yes.
Mr. Levonta Broughton, case number 24 CR 5576J. You are accused of criminal trespass and causing damage to property from September 9th, 2023. With regards to this misdemeanor offense, you are legally presumed innocent of the charge, and upon your entry of a not guilty plea, the case will be reset for trial. At the time of the trial, the prosecutor will have the complete burden to prove the charge against you beyond a reasonable doubt. If the prosecution prevails and overcomes your legal presumption of innocence, you could be convicted of this offense and face a penalty of up to $1,000 fine and or up to a year in jail. Given this information, how do you plead?
Not guilty.
All right. Your case is arraigned, and your case is going to be reset for trial. You will receive notice of when you will be brought to court for trial. Thank you.
Positions number 19 and 20, Mr. Hughley.
This is State versus Lloyd Hewley, case number 24 CR 4619E, accused of driving under the influence of alcohol less safe, reckless driving, and driving while license suspended or revoked from June 14th, 2024. Mr. Hewley also has a second case, 24 CR 5581E, accused of criminal trespass from August 4th, 2024. Mr. Hewley, you've been advised of your rights and your attorney is Mr. Tom White. And with regards to both his cases, how are we proceeding, Mr. White?
It's going to be a negotiated plea, Judge.
All right. Mr. Hewley, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, Ms. Falk?
On position number 19, state's recommendation on count 1 is 12 months, serve 80 days, credit for time served 40 days. That's going to be from June 15th to July 11th of 2024, August 10th of 2024 until today. Balance probated, DUI risk reduction, victim impact panel, $600 fine, 40 hours of community service, and ADET. On count 2, the reckless driving, we are merging that with count 1. On count 3, the driving while license suspended, it'll be 12 months concurrent with count 1 and a $500 fine. On position number 20, the state's recommendation to the criminal trespass is 12 months, served 26 days, credit for time served 13 days. That is from August 10th, 2024 until today. Balance suspended, stay away from the Kroger located at 590 Cascade Road in Atlanta. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
We stipulate.
Mr.
Judge-
Howard? Yes, sir.
And I would ask, and I understand I said negotiated, but given the amount of time Mr. Hewley's been in jail on a 1st and 10, we'd ask that you suspend his $600 fine, which is in your right. He's been in jail 40 days at this point. And the average person's only going to do a day or two on something like this. So he's just been unable to bond out. And,
Isn't this a minimum $300 fine under the statute?
That
It
is
is.
correct.
But you have you can suspend the fine. I mean, it's within the statute for you to.
I can change it to a $300 fine and add on another 30 hours of community service.
But he could do that on his own, Judge. All he has to do is tell probation he'd like to convert his fine to community service. We're asking outright, considering the amount of time he's been in jail.
Understood, but would he like to accept a amendment to a $300 fine plus additional 30 hours of community service?
Sure.
Well, I know you said sure. Does he say sure? Does he understand?
He does, Judge. We discussed it previously.
Okay. Anything else?
Just the fee waiver, Judge.
I will waive probation fees for up to 4 months. And that would be from, well, it will be through the end of this year. And January 1st, he will need to start paying probation fees.
Judge, we'd also ask that he be allowed to report by phone or mail. He's not going to be, he cannot drive or travel. He has some issues health-wise that are going to hamper him in some way, so.
I'm sorry, Mr. White. I did the first appearance, and from what I understood, is quite able to travel by bus.
He doesn't have a valid driver's license. I'm sorry.
Use public transportation.
Oh, bus. I didn't, I'm sorry, broke up there and I didn't understand what you said.
No, from what I recall with this case.
Okay.
So no, that he'll have to report every month on a DUI conviction. Would he still like to move forward with the plea?
Oh, yeah. Yes, Judge.
Okay, so with regards to Mr. Hewley, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in both your cases?
Yes.
You need to speak up, sir.
Yes.
And are you satisfied with your legal services?
Yes.
And do you understand that by pleading, well, I'm sure your attorney explained to you that your license will be suspended upon a conviction for driving under the influence of alcohol?
Yes.
Are you still willing to move forward with this plea?
Guilty.
If you decide to plead guilty to the charges in both cases, you would have to give up your constitutional right to a trial. You will not get the opportunity to go back to court, to confront your accusers, to challenge the evidence that will be brought before you, to have the state prove the charges against you beyond a reasonable doubt, and also miss out on the opportunity to present any defenses or arguments you may have. Are you prepared to waive these rights?
Yes.
How do you plead to one count of driving under the influence of alcohol less safe?
Guilty.
How do you plead to one count of driving while license suspended or revoked?
Guilty.
And how do you plead to the second case of criminal trespass at the Kroger on Cascade Road?
Guilty.
With respect to these convictions, on the DUI less safe, your sentence is 12 months to serve 80 days, credit for time served 40 days. Your jail time is concluded and you will report to probation on Monday, August 26th before 3 p.m. While you are on probation, you will pay a $300 fine with a minimum payment of $40 per month. Your probation fees shall be waived through the end of this year, and you will start paying probation fees from January 1st, 2025 onwards. While on probation for DUI, you will also complete a risk reduction class, which you must complete within 60 days of being released. You are to attend and complete a victim impact panel and enroll in an alcohol and drug evaluation within 30 days and submit yourself to any treatment that's required. You'll be required to complete 70 hours of community service, and you may begin your community service with any nonprofit agency that's not a church and not a school, and you must complete at least a minimum of 10 hours per month and 10 hours every month thereafter. With regards to the reckless driving, that's going to merge with count 1. On the driving while license suspended, that will be 12 months concurrent to the DUI conviction with an addition of a $500 fine, which you must pay with a minimum of $50 per month, beginning with the first month, and $50 every month thereafter. On the criminal trespass, your sentence is 12 months to serve 26 days, credit for time served 13 days, balance suspended. You are on notice that you're required to stay away from the Kroger located at 590 Cascade Road. If you return to that location, you will be arrested. Thank you.
Thank you, Your Honor. The next 24 hours.
Okay, next case, please.
Position 15 and position 16, Mr. Todd Holtzclaw.
14 and 16. All right, position 15 and 16 is Todd Holtzclaw. Mr. Holtzclaw's case is 22 CR 7052E, accused of operating a vehicle with no valid insurance on July 18, 2021. And he's got a bench warrant for failure to appear on August 2nd, 2023 under 24 FTA 1135. Mr. Holtzclaw, you've been advised of your rights and your attorney is Mr. White. Is this going to be a negotiated plea or a?
It is, Judge.
Mr. Holtzclaw, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Folk?
Yes, Your Honor. On the position 15, no insurance, state's recommendation is time served, 20 days, credit for time served, 10 days. That's from October 19th to October 20th of 2022 and August 15th of 2024 until today. I believe we do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. We will enter null pros as to position number 16 upon this plea.
Mr. White?
Stipulate.
Mr. Holtzclaw, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to challenge it in a court of law, to confront your accuser, be able to challenge the evidence, present your own defenses and arguments, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to operating a vehicle with no insurance, July 18th, 2021?
Guilty.
Your sentence is time served, which is to serve 20 days, credit for time served 10 days. Mr. Holtclaw, with regards to the bench warrant that is dismissed, once you are released, please go and check with the Department of Driver Services as to whether your license will be valid before you operate any car or vehicle on the roads of the state of Georgia. Do you understand?
Yes, ma'am.
Do not operate a motor vehicle until the Department of Driver Services confirms with you that your license is valid. I certainly don't want you to be arrested on any suspended licenses. Okay?
Yes, ma'am.
All right. Thank you. Next case, please.
That's it. The only case we have is on the competency calendar, Mr. Griggs. Oh, and the bench warrant, Your Honor.
All right. We're going to do our competency calendar. Is Mr. Austin here? Cameron Austin? Cameron Austin. Okay, Mr. Austin, you have a bench warrant for failure to appear in court on August 1st, 2024. You have a right to remain silent, and you have a right to an attorney if you cannot afford one. Do you have an attorney?
Yes, Your Honor.
All right, Ms. Ate, have you had a chance to confer with him?
Yes, I have.
All right. And what is the reason to set aside the bench warrant?
Your Honor, he did get a signature bond from you through pretrial services. He has been reporting every 2 weeks to his pretrial officer. His address has not changed. He did not have a stay away order or no further contact. So his address has been the same, the 1718 Castle Court. He started the FVIP course. He never received notice.
Ms. Falk, any comment?
Your Honor, let me I am curious about the notice, whether a notice was returned or not. So let me just take a look at that really quickly.
I'm looking at an Odyssey notice. It says it was printed. Doesn't say anything about being sent.
And it says it was printed August 1st, which was the date of the failure to appear.
Oh, wow.
So it was printed on the day that he had court.
That is what I was trying to get to. That's a pretty fast reset date, unless Judge Roth is on a, what do you call that? Super bunny rabbit that moves real fast?
Energizer.
That's Energizer bunny rabbit. Okay. Miss Tyson, has Mr. Austin been reporting to pretrial twice a month?
Yes, Your Honor, he was in compliance.
Okay.
Okay. Yeah, I'm not going to fuss about this. I'm fine.
All right. Ms. Ate, please submit an order setting aside the bench warrant. And Mr. Cameron, please remember to show up to court when summoned. This is going to be with Judge J. Roth. So if you're having issues with the mail or with your address at the clerk's office, it won't hurt you to come down to the clerk's office just to super check and make sure your address is correct.
Okay, Your Honor, it looks like, oh, sorry.
And I was going to say, please make sure you report to pretrial twice a month and comply with the conditions of your bond. Yes, Ms. Tate?
Nothing, Your Honor. Thank you.
All right. All right, Mr. Austin, you're free to go. Please don't get in trouble with the law until the order setting aside the bench warrant is filed, which should be within the next 48 hours.
Okay, awesome. Thank you so much, Your Honor.
Thank you. All right, whoever is going into a breakout, could you please start your video?
Judge, I've got a couple of things to address on the 9 a.m. calendar briefly, if we could.
All right, go ahead, quickly.
First
Mr.
of all,
Hassan, the evil eye. So.
Oh, God. Position 25, was reset from last week because the state was transferring the case. I need clarification if they're planning on transferring the case or not.
Lisa Lee?
That's
Position
correct.
25, we did not transfer the case. That's why we did submit a recommendation.
Okay.
All right.
Once submitted, and have one a position. Bear with me.
Mhm.
There was a abandonment of a minor child case where he actually purged on
What's,
that case. So
I did see that case, but can you tell me the case number again, or I'm just scrolling through this calendar.
so somehow or another.
It's position number 9 if you're talking about the child abandonment,
right.
Tobias Brown.
Right. So this is from March, and he actually paid a purge. And typically, once you pay the purge, those cases have, for as long as I've been here, been dismissed.
Totally agree with you. Totally agree. So I need to know why he's being held.
He's actually being held on a number of other charges that are unrelated to this charge.
Right, but that's not the point. This charge should have disappeared when he.
All right, let me see. Purge paid. He's got a child support contempt, which I'm assuming is $1,000. Was that the one, the $1,000 cash bond on the contempt charge?
That was different, Judge. He did pay the purge amount. There's one above it, if you see it, and the state added another child abandonment. He only had one count, and then another one was added.
Okay, Mr. White, if you want to, you mean there's an additional count for child support contempt, or?
Additional
There's an
child
additional account for child support abandonment.
So he paid it for one count? Does he have another count that he has to pay for?
At the same time period?
That's what I'm saying. On the booking screen, it says child support contempt, $1,000 cash bond. And then he's got that purge amount. So it appears to be the same charge, but I just want to confirm. And you're absolutely right, Mr. White. Does appear to be for the same charge. And but if he's paid that $1,000, I'm going to dismiss the whole case.
Thank you, Your Honor.
So, Ms. Falk, final salvo. Any objection to a dismissal?
Yes, I mean, just because the tradition has been to dismiss the case upon the payment, with abandonment of dependent child, the fact that the defendant has been convicted is part of recidivist for that defendant on abandonment of dependent child. And so we are not agreeable to null processing this case. If this court wishes to DWOP it, you absolutely have the right to, but we are not null processing.
It's dismissed. Thank you. So this case on Mr. White under case number 24CR002-700G, please make a note that the abandonment of a dependent child charge is dismissed as the amount has been purged, and the contempt charge is dismissed.
Thank you, Your Honor.
Okay, if you don't, that case is gonna hold him. So both of these items need to be addressed. Anything else, Mr. White?
So I'm gonna get an order for that?
That's
Mr.
what
White
I was asking. You would need an order for each one separately?
No. In the same body, make sure that you say that the abandonment charge is dismissed as purged and the contempt charge is dismissed by the court.
Okay, perfect. Oh, thank you. I'll get that to you.
Anything else, Mr. White? No? Okay.
That's all I had, Judge. Thank you.
Miss Grace, before somebody else stops me, could you please throw me into a breakout room with everybody else who's on the screen?
So just so you know, I might stop you. I have Mr.
Sure.
Griggs.
I know he's there. Give me a moment.
Okay.
We'll come back and address him. Promise.
All right. All right.
Oh, Kasha is here. Good. Thank you.
Hello, Your Honor.
Hello, hello. Thank you for joining. All right, Deputy, we are ready to address Derek Grigsby. Derek Grigsby's case number is 23 CR 04406G, in which he is accused of the following offenses: reckless conduct and disorderly conduct from July 12th, 2023. He's got a second case, 24 CR 001591G, in which Mr. Grigsby is accused of battery, family violence from April 2nd, 2024. Mr. Grigsby, you have a right to remain silent about the facts and circumstances of the cases. Anything you choose to say, your statements can and will be used against you in the treatment of your case. You have a right to an attorney if you cannot afford one. Ms. Maureen McLeod is your appointed counsel to represent you in these cases. How would you like to proceed?
I would like I would like new counsel.
I beg your pardon?
I would like new counsel.
I don't understand what you're saying. Speak up clearly.
Oh, I would like new counsel.
New counsel?
Yes.
Denied. Ms. McLeod is your appointed counsel.
All right, so.
Would you like her to continue representing you?
No.
All right. In that case, then you also have a right to hire your own attorney, or you can choose to waive your right to counsel and represent yourself. How would you like to proceed?
I would like, let's see what Ms. McLeod has to say. I mean, I would like to see what's going on.
Ms. McLeod will be representing you, and if you'd like to have a conversation with her, you're certainly entitled to a confidential conversation with her.
I need a conversation with my attorney.
All right, Ms. Grace, if you could place courtroom 2 and Ms. McLeod in a breakout, please. Ms. Grace. And oops.
She's doing it now, Judge.
Okay. Do you know if any of the public defense attorneys in courtroom 2 would be able to come on a separate device? Maybe Miss Atay or Miss Kim? Because I just want to go over the calendar while they're talking.
I don't even know if they have a separate device. I have to go in there and ask. I don't have, I just only I can communicate with them before they went into the breakout room. I can't chat with them or nothing like that.
Do you have any way?
Unless you call over there. Let me see if I can find
All right, thank you.
the number to call over there. And just, I was going to go over the calendar for you.
I know, but I need the PD available too, one of them.
Okay, hold on. Let me see if I can call to the courtroom.
Miss Kim or Mr. Tay are very good at getting the device.
Judge Law.
Yes, Ms. Lewis?
They left.
Okay, that's all
They
right.
left. Only person in the courtroom was Miss McLeod
No
and
problem.
the inmates, so they gone.
No problem. Okay, Ms. Falk and anyone else on the add-on calendar, positions 1 and 2 were null crossed. Position 3 was a plea. Position 4 was a plea. Position 5 was null crossed. And position 6 is reset to August 27 for a Spanish interpreter. On the main calendar, positions 1 and 2 are reset to August 29. Position 3 is null crossed. Position 4 null crossed. 5 plea. 6 a plea. 7 was null crossed. 8 is further notice for trial is been arraigned. Position 9 Tobias Brown, that is dismissed. Position 10 Jeremy Campbell is a waiver of arraignment and further notice for trial. Position 11 Elliott is a waiver of arraignment, further notice for trial. 12 is a plea. 13 is a plea. 14 Guthrie is a plea. 15 was a plea. 16 is null crossed. 17 is null crossed. 18 is a plea. 19, I believe that was a
plea.
20 was a plea. 21 Kenneth Jackson was a plea. 22 was I didn't write.
Plea.
It was a plea.
Okay. 23 was a plea. 24 Jeffrey Ladd was a plea.
Correct.
25 Lisa Lee. Are we resetting that case?
We're gonna have to because he didn't give me
because
he didn't give me no information. It's gonna go to Thursday.
All right.
820, what is it, 829?
9. Yeah.
And that won't prejudice the defendant based on the amount of time we're asking for.
All right. Position 28, Charles Lowe. Any announcement?
You mean 26, Judge?
Yes.
I don't have an announcement on that.
26, let me see the last day. She sent up an update information.
Not guilty
It
plea.
says not guilty.
Okay.
So
I'm assuming she's gonna waive the arraignment. That was Mr. White. So I'm gonna have to ask for a waiver from him.
Yeah. And then 27 is also a waiver of arraignment with the
Mr. White.
Yeah. And then 28 Damian Mitchell. That goes with position 27 waiver. We'll need the documents from Mr. White.
I definitely will get them.
Willie Mobley is a plea. That's position 29. 30 is a plea. 31 is null crossed. 32, 33, 34, 35, 36. Antoinette Smith. That's a waiver of arraignment and further notice for trial. 37, Marcus Smith.
Judge, also 35, 36, you amended the bond to $1,000 surety.
Yes, I did.
Okay.
30, Marcus Smith, 37. Y'all know the announcement?
He's transferred to Superior Court. I got the order and they gave us the number.
Okay, this is a transfer to Superior Court. Position 38, Jonathan Taylor is a waiver of arraignment and further notice for trial. 39, waiver of arraignment, further notice. 40, further notice for trial. 41 is reset to August 27 with a Spanish interpreter. Position 42 was a plea. 43 is null crossed. 44, Latavia Winson.
Last announcement I have on here, that was the person that was in Grady. That's what the one she was talking about. Miss Kim. She didn't really illustrate. She just got Grady on here.
All right, it's reset to August 29th. Anthony Watts, 45 is a plea. 46 is reset to August 29th. 47, Brianna White is reset to August 29th. 48, Tyrone White, 48 and 49.
Was a plea.
That was a plea.
Position 50 is a waiver of arraignment and further notice for trial.
And you amended the bond to a $1,000 good bond on each charge, which is a total of $3,000.
51, Monte Wilson was a plea. Same announcement for 52, and 53, Woodard was a plea.
That's correct.
All right.
Ooh, I got a lot of paperwork.
With well, that paperwork's the least of your problems. You have to chase down Mr. White.
I gotta chase down all of them.
Hey, Miss Kim will be. Just chase down Mr. White for those other announcements.
Yeah.
We can close out the breakout room and we're ready to address Mr. Grigsby.
Okay, I'll close them out.
And
they're popping out now. They coming out now.
Miss Lewis, do you have everything from me on the FTAs?
I'm looking now. I've been printing them as we've been going along. I'm trying
Cool
to.
beans.
I'm trying to.
If I owe you anything, I'm going to be offline for about an hour, but I'll be back on I'll be available at about 1 o'clock.
Okay, I've been checking, so I had to do my check here.
Completely understand.
Returning back to State versus Derek Grigsby with regards to the two cases, Ms. McLeod, do you have an announcement? I'm sorry, you're on mute.
Yes, Your Honor. I will be going to see my client. He's now in Cobb County, so I can give him the discovery because he does want to see the discovery in both of his cases. I would also like to reach out to the state to see if there's a plea offer. Well, my client has indicated that he feels that maybe any plea offer may not be a good one, but we don't know that yet until we receive one. So I'm asking for a plea offer to resolve both of his cases from the state, and I can go and discuss.
All right. Would August 29th be adequate time?
I'm sorry, Your Honor.
August 29th be adequate time, or you want a September 5th date?
The September 5th is probably more reasonable, Your Honor.
All right. Mr. Grigsby's both cases are going to be reset to the SAP calendar on September 5th, 2024 at 9 a.m., during which time Ms. McLeod will continue representation of Mr. Grigsby. And Ms. Polk, when you have a moment, if you could email a recommended offer to Ms. McLeod for both these cases so that she can share that with her client.
Yes, Your Honor.
All right. Ms. McLeod, thank you so much, everybody. I will see you sooner than later. We'll see. Okay.
Ms. McLeod, send your paperwork to me, please.
I will.
Thank you.
Mr. Grigsby, we are concluded. Deputy, anything else, sir?
That's it.
All right, sir. You have a great weekend. Talk to you later. Bye-bye.
Thank you.
Thank you, everyone. Bye-bye.
Bye, Your Honor.
Bye-bye.
Bye-bye.
I don't know. I got to check. I know what Thursday.